Welcome back, guys. So in this lecture we are going to be talking about three things. First of all, we are going to interrogate the basis for the appeal of the removed director. We are going to interrogate as well the basis for the argument of the company as well as the judgment of the Supreme Court. So let us go straight to the argument. According to the learned counsel for the removed director, he argued before the Supreme Court that the appointment of the appellant as an employee or servant of the second respondent must be treated separately from his appointment as a director of the company, so that his removal as the director must comply with the provisions of the Companies Act 1968. It was submitted that the appellant was not properly removed as director of the second respondent, and the case of Olaniyonu versus British American Insurance Company was cited in support. Now, for those who are going to be taking company law second semester, it is very important for you to note these certain cases. Why? So that when you are reporting this particular case in your exam, there would be a very good impression that you actually read the case. There are three very important cases that were cited by the lead counsel for the removed director. The first one is Olaniyonu versus British American, and it was cited to support the argument that his employment as a director is different from his employment as a special assistant, and both of them have different modes of removal. While the employment as special assistant was governed by the contract, his employment as director was governed by section 175 of the Companies Act 1968, equivalent to our section 288, and that case is Olaniyonu versus British American Insurance Co. The counsel further argued that the appellant could only be removed as a director in compliance with the provision of section 175 of the Companies Act, and if this was not done, then the removal must be held to be null and void in accordance with the principle laid down in Shitabe versus Federal Public Service Commission. And finally, he further argued that in the absence of compliance with the provision of section 175 of the Companies Act 1986, the appellant appointment as director remained valid and subsisting. And then he supported that with the case of Chief Udegboe versus Araf, Rose and others in his oral submission. According to the counsel for the company, the learned senior advocate submitted that where there is no fixed period of appointment of a director, the provision of section 175 sub 1 of Companies Act will not apply. That is, he was following what the Court of Appeal has said. So he wanted to use the basis of the judgment of the Court of Appeal to persuade the Supreme Court to also hold in the company's favor. He contended that the appellant was appointed at pleasure. There is appointment at pleasure. And therefore, his tenure could be determined at any time, and the provision of 175 subsection 6 of KAMA would apply. Now, as already shown in the judgment, the appellant's first appointment was that of a special assistant to the first respondent. The condition for the appointment, as given in Exhibit 16, is amongst other things that the appellant appointment could be determined or terminated by being given 3 months notice or 3 months salary in lieu of notice. The letter terminating the appointment is Exhibit 15, which was written on 31st of October 1983. It had been argued and held by the trial court that this letter, having been written after the commencement of the case, had no bearing on the case and discountenanced. The essence for the trial court stating this is because what this particular company did was that instead of them to actually issue the letter, the first thing that they did was that they dismissed him orally. Then when he went to institute action in court, they now said, let us go to our contract, that is in his employment. What did we say? Okay, we should give him 3 months notice. They now sent letter of 3 months notice. The trial court held that the letter had no bearing in this case and was discountenanced. So according to the learned counsel, he is asking that the question therefore is, could this be right? And then he answered, I don't think so. He continued that a close examination of the appellant's statement of claim reveals that his action concerned his removal as executive director and has nothing to do with his appointment as special assistant to the first respondent. It is therefore wrong to regard Exhibit 15, which was that letter of termination, as wrongfully issued by the second respondent, because according to the trial court, it was issued after the commencement. Therefore, it was wrongfully issued. It should have been issued immediately they wanted to actually terminate him. Exhibit 16 is the contract of employment. Exhibit 15 is the letter that terminated. Do you understand? Exhibit 15, according to the court, is wrongfully issued. It followed, therefore, that the appointment of the appellant as special assistant was terminated by the second respondent with effect from 31st of October 1983. Whether the termination of the appointment is right or wrong is not the question before this court, since it did not arise as far as the appellant's case is concerned. You see, the learned counsel realized that let us not argue through executive director procedure. Let us follow these special assistants, because he knew what the Court of Appeal has stated. The Court of Appeal stated that if you don't have a fixed period, you are not a director. So he is saying before the Supreme Court, my lord, there is no case here. Because the appellant here is not even arguing about his dismissal as special assistant. The appellant here is arguing about the dismissal as executive director. But he wasn't even executive director in the first case. Because according to the decision of the Court of Appeal in this case, he did not have a fixed period of office. And for Section 175 to apply, which is our own equivalent of Section 288, you must have a period of office. So my lord, there is no case. He is not arguing that he was removed as a special assistant. If he was so arguing, then we can say, okay, we did not dismiss him properly because we dismissed him orally instead of dismissing him by either issuing the notice or by 3 months salary. Okay, but that is not even the issue before this court. The issue before this court is that we did not dismiss him as executive director. But it is not even executive director, my lord. That is what the counsel for the company is saying. But the counsel for the removed director is saying, no, my lord, my client is an executive director. He was removed as special assistant. Such removal we are not even contending at this point. But what we are contending is the removal as executive director. As executive director, they must follow the provisions of Section 175. Because if you don't follow it, it means that such removal is null and void. And if you read the case of IWUCHUKWU versus Aras Ross, it tells us that where such removal is null and void, then the appointment as director is still valid and subsisting. So therefore, let us go to what the Supreme Court held in this case.